Hi, my name is Peter Lorence, a Senior Associate Solicitor with Irwin Mitchell. I've specialised in serious injury cases for over 12 years and all too often see the life-changing impact of crashes on our roads. As part of Road Safety Week, I wanted to offer my guidance on the all-important issue of what to do after a crash. A safe road system has 5 layers of protection to prevent human error resulting in death and serious injury. These are safe vehicles, safe speeds, safe roads, and safe road users. These 5 layers aim to stop crashes from happening, but where they do occur, there needs to be excellent post-crash response and care, reducing the harm suffered where things do go wrong. Everyone has a shared responsibility for road users' safety, and it's critical to be alert of what to do when things do go wrong. Whilst everyone can react differently to these scenarios, I hope this guidance can ensure the best possible outcome. If you are involved in a crash, the police need to be informed. They should then attend the scene. If there hasn't been any injuries, it's unlikely the police will attend the scene unless the driver involved refuses to give their details or the collision has caused an obstruction in the road. It's always helpful to gather as much information as possible. This includes the name and contact details of the driver, along with the contact details of the vehicle's owner, along with its insurance details. Please also try to obtain the name and contact details of any witnesses and a brief note of what they saw. Please also try to obtain any dashcam footage where available, along with CCTV footage from any nearby buildings or businesses. You can ask for a copy or at least ask for it to be held or retained, pending a further formal request. Please also note down the vehicle registration numbers for those involved. It's always useful to take photos of the scene as well as any video. This can help record the vehicle's positions and any damage caused to them. It might also reveal any contributing factors to the accident, such as frosted up windows or maybe items that may have obstructed the driver's view. Now, what do you do if the driver doesn't stop after the crash? Now, pursuant to the Road Traffic Act, they are under a duty to stop, and therefore if they don't, please contact the police as soon as you can. The police may investigate the incident and the Crown Prosecution Service may decide to prosecute the driver. Their resources are limited, however. We often see police not taking any further action, or the CPS, or rather Crown Prosecution Service, declining to prosecute despite our clients having suffered life-changing injuries. It's no doubt frustrating when this occurs. You may feel that the justice against the driver responsible for the crash hasn't been delivered. Despite this, you may still be eligible to make a claim for compensation. Many of our cases are successful where there is no prosecution or conviction. If you were injured in a crash, you can claim for compensation for the injuries themselves and their impact on you. There are also further losses that can be claimed. These can include your loss of earnings, cost of surgery treatment now and into the future, travel expenses, cost of aids and equipment, adaptations to your home, the cost of care and support. You could also claim for the vehicle damage, along with any items broken in the crash. The circumstances of each claim is unique. This means the amount of compensation you might receive is unique to you too. 2 people might sustain identical injuries in separate crashes, but the value of their claims can be completely different. Many factors can influence this, which includes the severity of the injury sustained and their impact on you, and any long-term care and treatment needs. The circumstance of the accident can also affect the value of the claim, as well as your unique circumstances, such as any pre-existing health factors, as well as your earning position. To help investigate this, we would gather medical evidence to confirm the full extent of your injuries and longer-term prognosis and their impact on you. In making these inquiries and gathering this evidence, we can ensure you receive the maximum you can through the claim process. If you aren't sure whether you're entitled to make a claim, you should still contact specialist personal injury solicitors to find out. I have seen incidents where the police have advised an individual not to bother making a claim because there wasn't seen to be a viable claim. Even if you have contributed to the accident, for example, you may have failed to wear a seatbelt, or you may have stepped out into the path of a vehicle and the police considered there was nothing the driver could have done to avoid the crash, there may yet still be a viable personal injury claim. In respect of time limits to make a claim, you normally have 3 years from the date of the incident to bring a claim. This can differ if you're bringing the claim on behalf of someone else, such as a child. If it is a child, they have until they turn 21, or rather 3 years from the point they turn 18, to make a claim of their own. If someone has died as a result of the accident, the time limit is typically 3 years from the date of death. If someone is considered to not have capacity to advance a claim of their own, then there is no time limit as such. I hope this guidance has been helpful, and please don't hesitate to contact me for any further information or support. Thank you.